Assalamu alaikum students, be ready. Para learned counsel for the petitioners challenged both the impugned judgments on the ground firstly, that the petitioners herein were entitled to the transfer of the suit house in their favor on the basis of the agreement to sell, which had to be specifically enforced as being pertaining to immovable property secondly, both the learned lower courts had wrongly assumed that the agreement to sell was without consideration and thirdly, the respondent number 2 was not a bona fide purchaser para in so far as the first ground is concerned, originally the contention of respondent number 1 was that he had executed no agreement to sell in favor of the petitioners herein, although he admitted the factum of mortgage but in his evidence he admitted his signatures on both the documents, namely, the mortgage deed and the agreement to sell, and pleaded that they were without consideration However, in the sale deed in favor of respondent number 2, he had admitted the factum of mortgage in favor of the petitioners He did not produce any evidence to show that he had not executed any agreement to sell in favor of the petitioners or that the said agreement was executed under duress or misrepresentation It is a registered document and its contents and execution have been proved according to law The mere denial of execution have been proved according to law The mere denial of execution and then admission of signatures thereon by the respondent number 1 clearly proves the execution of this document It shall thus be seen that the agreement to sell the house in question was actually executed by the respondent number 1 in favor of the petitioners and it was also got registered The existence of these documents cannot, therefore, be denied This agreement pertaining to the sale of immovable property had to be specifically enforced para so far as the second ground is concerned, it may be mentioned that the transfer price of the suit house was 12,673 rupees and it was mortgaged with the petitioners for 15,000 rupees It appears that the intention of the parties was that this mortgage amount shall be the sale price of the suit house and that is why no other amount as sale price was mentioned in the agreement to sell The mere fact that the vendor agreed not to receive any additional amount as sell a fictitious document or the transaction as without consideration even otherwise this was not the plea of the respondent number 1 in his pleadings by holding that the agreement to sell was without consideration, both the learned lower courts have travelled beyond the pleadings of the parties and have taken into consideration matters extraneous to the pleadings During the days when the suit house was intended to be sold to the petitioners, 15,000 rupees could be a reasonable price thereof, and the respondent number 1 willingly and voluntarily agreed to transfer the suit house in favor of the petitioners on that very price, which he had received in